Heledd, and I'm very pleased to have Kristopher Kilsby here with me today. Kristopher, do you want to just tell us about yourself and why you've volunteered to come and talk to me?
Absolutely. I'm Chris Kilsby. I am a cost lawyer. So I've been in the world of costs and legal costs for just over 10 years now. So started back in 2014. Um, I'd gone through, I'd done a law degree, I'd done an LLM, and I wasn't really sure. Well, I was in a position where I couldn't quite gamble the amount of an LPC. So I wanted to get some legal experience behind myself. So I ended up just applying for lots of different positions. And one of the positions I ended up applying for was for a cost draftsman at a law firm. And I'd never heard of it. 3 years of a qualifying law degree, you do your LLM, you just you just assume you do the work and you get paid at the end of it. But
Be nice, wouldn't
turns
it?
out, yeah, exactly. And found out that there's this whole separate area dealing with legal costs, arguing one way or the other. And when I started to get into it, I was actually like, this ticks all the things that I wanted from a legal career. So it deals with drafting, so drafting bills of costs, but also pleading, so points of dispute and reply where you're putting forward formal arguments. It deals with numbers, which I was quite liked. I know numbers and dealing with figures can be either something that solicitors absolutely love or something that they'd rather just push away and give it to someone else and say, just work that out yourself.
Yeah.
But I really enjoyed working with numbers and also the chance for advocacy as well. So yeah, I thought, right, this seems like a really good avenue, and like I've not really looked back. And I'm sure that's pretty much, if you spoke to any cost lawyer or cost draftsman out there, they'd be like, well, yeah, I just fell into it, didn't know it existed at the start, and here I am, however long afterwards, made a career out of it. And yeah, it's just one of those weird little vortexes that once you get into it, it's quite tricky to get out because it is ever changing and ever evolving.
But really important,
Um,
isn't it? Because as you say, I mean, as you say, why I sort of I sit there and go, right, well, I'm going to do some work for you, and I'd like to get paid. Thank you, and that's nice. And then and then generally my client's pretty good, thank you. Because we've
yeah,
agreed that, and it's fine. But then certainly the litigation piece, well, in the court protection litigation I do, there's all that sort of excitement and enthusiasm. You go in and do all the litigation, and then at the end of it, it goes, oh, and by the way, we'd like some costs. It's sort of
yeah,
just like,
yeah.
it really shouldn't be just that bit at the end, should it?
No, no, it should be something that everyone's thinking from start to finish. And there's nothing worse than like getting to the end of a case. You've done everything that you've worked really hard, you've been successful, you get your costs, fantastic. And then you look at your retainer or your CFA or whatever it is, and you're suddenly like, my hourly rate's half of what I was expecting it to be. Why didn't I check this? And then suddenly
Yeah.
you're limited to that hourly rate. You're like, oh my God, I've just thrown away a load of money. And yeah, there's nothing worse than that. So it's something that should always be borne in mind, as whether it's at the start with funding arrangements, agreements, or during, like figuring out, well, it's all well and good. I'm going to spend five, or I'm racking up my billable hours. I'm hitting my billable hours targets. But if you're not working efficiently or you spent far too long on a document, you're not going to recover those at the end. They're not really worth the paper they're written on. So it's something to deal with during, and with like contentious stuff, litigation stuff. You've got budgeting as well, which is massively important now. It's been around for 10 years and still feels like the courts are finding their feet. They're much better now than they were. But um, yeah, I think that's one aspect. But also, people thought, oh, well, fixed cost coming in, it's going to simplify everything. I don't think it has. I don't think it will, because now there's arguments over what banding of fixed costs you're going to be entitled to and things like that. And then at the end as well, that's where the bun fight can be, whether it's inter parties with litigation, so paying party, receiving party, or even if it ends up being even with your own client because they're unhappy with what they're having to pay for you, and then they're potentially seeking a Solicitors Act assessment.
And I remember when I was trainee, my boss said, so when I was when I was a trainee, this is going back to the dark ages, my boss used to just weigh files. I think it's about that
Yeah,
much. And he's like, we don't do that. What we actually do is we sit down and we look at all the time recording. And I think time recording and costs and recovery is an art and a science.
absolutely, absolutely. Like your cost will live and die by your file. And I've seen people run cases where they've done fantastic work, they've secured a really good outcome for their client, but because the file's not really there, they've not been able to evidence the work that they've actually done. It sort of gets, they don't get the full payment that they should do, either when it goes to an assessment or just on negotiations with either your with the losing party. So yeah, I think a good file note is incredibly, like, it's worth its weight in gold, really,
Yes.
whether it's litigation or even like court protection as well, because the
Yeah.
court can see it.
Yeah. And it's right, isn't it? Because what have I done? I know
Yeah,
I know
yeah,
what I've done, but if there's no evidence, it's like trees falling in woods that happen. Um,
absolutely.
but you mentioned Solicitors Act assessments, which are probably enough to strike fear into people's hearts
Yeah.
anyway. So talk to me about Solicitors Act and how's that? Why does that come about? Is it one of these like ancient bits of legislation that is possibly due a refresh, if I can be polite, or is it still fit for purpose? And what does that look like?
Yeah, so Solicitors Act was introduced in 1974. So that was when it sort of initially codified, but actually the main elements of a Solicitors Act, namely that a client should be able to have their costs, their solicitor's costs, assessed by the court, dates back to, I think it's either the 18 or 1700s, really. It's not massively changed. So even then, I think there was a fear either by Parliament or courts or whoever initially brought it forward that there were solicitors or advocates, attorneys that were potentially, they recognised that imbalance of power in the relationship, namely a solicitor, they know exactly what's going on, whereas the client is 9 times out of 10 going to be lay, going to be wholly reliant on the solicitor, and therefore won't necessarily know whether the work that's being done is fully justifiable or reasonable or anything like that. So yeah, I think it's been around for a long time, and it is definitely due for a refresh and being brought into the 21st century, because it's far too arduous at this moment in time, and also there's so many different technicalities now that are being brought before the courts. And I think costs, apart from, there are some judges that really do like costs and like to get stuck into the technicalities and the nitty gritty, but I think if you canvass the entire judiciary, I think costs would come down quite low as something, oh, I suppose we have to deal with this at the end of the case.
Well, I guess just thinking, 1974, I was like, okay, so oh yeah, that's 50 years ago. And I'm thinking, oh, that predates email and mobile phones and text messaging and WhatsApp and whatever the million other ways there are now of communicating. It's no longer a case of, well, I've thought about it, I've written it down, I've gone to find an envelope and a stamp and posted it and waited a bit for a response to come back, and it's quite neat. Correspondence
Absolutely.
wise, isn't it? It's like actually there's stuff floating around all over the place, isn't there?
100.
And that's got to be a huge, well, it is a huge difference, isn't it, from how work was happening in sort of 50 years ago. And I guess, how easy is it to marry up the 74 Act with that kind of way of working?
Well, I think there's normally this 74 Act sort of sets out the different formalities for something to be passed as a statutory bill, and that's sort of the first hurdle, is whether it complies with the Act or not. If it does, then the court can then make an order which will allow the client to then get that bill assessed. If it doesn't, then it means that the solicitor has to go back, draw up a statutory compliance one, and then the process will start again. The court will then make an order. But there's lots of different timeframes involved. So from delivery of the bill, a client is guaranteed to get an order assessed or get an order for assessment if they apply to the court and ask for one within 1 month. If it's between 1 month and 12 months, the court has a bit of a discretion, but I feel like 9 times out of 10 they will do. And if it's after 12 months from delivery, then the court needs to find special circumstances. So it's to try and balance sort of like the consumer protection side of things against offering solicitors certainty, because either you've got money on account or you want to be able to, if the client's not paying, you want to be able to proceed to sue on that bill so you can get the funds that you're rightfully due. So they're the two sort of competing approaches that the court has to balance, and the Solicitors Act does have those timeframes included, and there's also further timeframes depending on if payment has been made, and they're a bit more hard and fast. So if payment has been made and 12 months has elapsed, then the Solicitors Act says, well, no, there's no more. There won't be an order made. So if you're a client and you want to get an order, you'll be arguing, well, actually, that wasn't an interim statutory bill, the timeframes haven't started, and you'll try and pick out lots of different reasons why. Could be that it's not specific enough, it doesn't have a clear start and end date. It could do with delivery or signature even, or whether it even had, like, whether it was clear that it was a final amount for that period of time as well. So there's lots of different reasons why, and likewise a solicitor may, because a statutory compliant bill will be deemed to be final for that period, if you've drawn it up wrong and you've got your maths a little bit fuzzy, you suddenly find a load more whip somewhere else that should have been included, you'll probably be wanting to argue, actually, no, that's not a statutory bill. It was actually a request for payment, which means that you can then go back and revise the bill and you can increase it to cover that whip, so to speak. So yeah, there's lots of arguments about it. And the court's seen a massive flurry, both in the private client side of things. So very recently, like in contentious probate matters and even just non-contentious probate matters, and arguments over executors' costs and solicitors' costs. But also since LASPO and the prevalence of making deductions from damages, whether for success fees or shortfalls, that has generated a huge amount, and much to the court's frustration. They don't really want to be dealing with that. I think it was in the case of Belsner where they're almost advocating that these sorts of disputes should be going to the legal ombudsman and not before the court. However, the Solicitors Act is still there and it's still available to a client if they are unhappy with their bill.
Okay. So you mentioned statutory bills. Confession time, slight mysterious things, statutory bills as opposed to other bills. Talk us through that.
So essentially with a statutory bill, it needs to be for, first of all, it needs to be for a clearly defined period of time. Normally, it will cover either a period of time, so you have a start date and an end date, or it will cover a period of action. So in like probate matters, you'll probably say up to the grant of probate, the costs will be this. once you've got the grant of probate, you can then start to like use the assets accordingly. So you could start paying yourself as well, and using the estate in that way. Or they'll come right at the end and they'll cover the entire period. So there'll be what's known as a final statute bill. So it covers all of the work that's been carried out, and you have again, you say this is for all the work that's been done. The key things that you need to make sure is that it has that clear sort of time period. You need to try and make sure that you've got a narrative of some form. So whether that, again, there's so much case law on exactly what detail needs to be in there, or in some periods or in some invoices, it's very much a case of if there's a narrative, so you're saying what work has been done in a very brief description, then that's sufficient. I believe there was another case law which essentially said, well, please see attached our WIP printout, which clearly sets out all the work that's been done, and that was held to be sufficient. But yeah, you need the client needs to be able to understand the amount that's on the invoice relates to what work. So whether it's a narrative and you're saying, well, we've had correspondence with yourself, we've obviously wrote and obtained all of the assets into the estate, and then we've gone through and proceeded with distribution, we've applied for a grant of probate, we've got letters of administration, whatever it is that you've done, can detail that, then the client's able to make a informed decision whether they want to challenge it or not. It does get a bit murky. The case law is all over the place because certain people will want to argue one way or another, and they've really picked out the technicalities. So I believe in some cases, if you say this is a statutory bill, but it doesn't meet the requirements of a statutory bill, then it's not. And likewise, if you don't call it one, but it meets all those requirements, then the court will hold that actually it is a statutory bill. Another thing is it needs to be a demand for payment. It can't just be a request. So again, it's about saying, well, look, this is the final bill. We want you to pay. It's not just saying, oh, can you put some funds on account? And that we'll hold on to that. It's very much a case of we would like payment, please. And then the final,
I like the difference between request and demand. I can imagine. Yeah. I request some money from you. I demand that you pay my fees now.
Absolutely.
It's probably ways of dressing it up, I suppose.
And as with most things legal, it all comes down to semantics and exactly the phraseology that's used. And then the final two things, it must be signed, whether it can be an electronic signature, so it has been updated to include that provision, and it must be delivered. So very Stevie Wonder-esque, that it must be signed. You can seal it if you want, but it's delivered. So yeah, and again, there's plenty of case law as to say, well, what amounts to delivery, and things like that. But as long as you're making sure that you are actually sending it out to the client, and like I say, it is signed or it is accompanied by a letter that is signed on behalf of the firm or partner, then yeah, those are the key sort of requirements for it to be considered a statutory bill.
Okay. So if we are at that stage where costs are being assessed and there's that nail biting sort of waiting, was it many months for it to go through assessment, don't hold your breath, isn't it at this point? What are you what sort of reductions would you say are you likely to see? I mean, or can it be, how long's a piece of string?
I think, like I said earlier, it is a bit, how long is a piece of string? How good is your file of papers? If you can really justify it, then you're probably not going to see a huge amount of reduction. But equally, if a bill has been padded out with a lot of time, whether like certain aspects have taken a lot of like time to actually prepare. And actually, when you look at the final document, you're like, well, how on earth have you spent 15 hours on 3 sides of A4 for a witness statement, for example? The court is going to be asking some questions. In respect of a Solicitors Act assessment, it is more favourable to a solicitor. So the cost will be assessed on what is known as the indemnity basis. So that does 2 things. The first thing, it sort of places the burden of proof on the client. So they will need to show that the costs have either been unreasonably incurred or are unreasonable in amount. And the second point will be that if the client has informed consent and has approved the cost to be incurred, then the court will say, well, actually, we're going to hold that there is a presumption that because you've approved these costs, that they are reasonable in amount. So that you'd have to go a lot further to actually get behind that. However, if there are some unusual costs in there, so I think there is one case where essentially budget overspend in litigation claims, the court has said that that's really an unusual amount if you're going to try and seek that from your client, because you're not going to recover that on an inter-parties assessment. You need to actually explain that to the client and explain why and get their informed consent they are willing to accept that payment, or either from a deduction from damages or that they actually pay that themselves. So there's those 2 things. So normally we're maybe looking at anywhere between 85 and 95% recovery of the cost claimed. That's on a rough and ready basis, but like I say, if there are certain cases where the estate is incredibly straightforward, but for some reason £100,000 worth of costs have been incurred, and the court is going to want to have a look at that, and they'll go through the file of papers, and reductions could be made significantly. Like that could be because you've had a grade A dealing with this throughout, when actually you're a full service law firm. You've got lots of grade Ds and grade Cs who you could delegate that work down to. You could save some time, save some costs as well. So yeah, it's a really tricky one. It will always depend on the work that's been carried out, and also the bill of costs itself and the file of papers.
Okay, so I mean, are there alternatives to a Solicitors Act assessment, or is it just one size fits all?
So that's one area for sure. It is very costly, because whilst the initial step is just making an application to the court for that order for assessment, if the solicitor wants to rely on some of the timeframes in the Solicitors Act, or disputes whether the bills are interim statute bills or things like that, then suddenly the cost can run away, because there will be directions hearings where the court will consider just those issues alone before they even consider whether to make an order. And that's just to get the order, let alone going through the rest of the procedure to do points of dispute, points of reply, and then an actual assessment in court. So it can be really expensive. It can be a very long and drawn out process. And so very quickly, if you're arguing over 10, 15, or like maximum 30% maybe, like the cost of the assessment are going to far outweigh the actual reductions or savings you could make as a client challenging it. And likewise for a solicitor, it's something that you need to be alive to and commercially alive, that if you end up being ordered to pay the cost of assessment, it could be quite sizable. So for alternatives, if you've already got an order for costs, so this sometimes happens in like court protection, contentious court protection as well. The court will make an order that like a deputy will be entitled to the cost to be assessed. In some contentious probate matters as well, I've seen orders where if new personal representatives are appointed or new executors are appointed, the order will specify that their costs will be payable from the estate and subject to assessment, and then you've already got that order. So there is a provisional assessment route, which is what is normally undertaken for most court protection matters, which is, I believe, CPR 4719. And that means essentially.
I'll hold you to it.
But it means that you can send your bill of costs in, send your file of papers, and the court will assess it on the papers. So you don't need to worry about going through the whole rigmarole of points of dispute, points of reply, things like that. The court here has cost officers that are trained to assess bills and assess what is reasonable and proportionate, or go through and assess it on the papers, and then you can have a decision then, but you've already got a good indication. And also legal ombudsman route as well. If you're a client and you're looking to challenge those costs, that's probably the most cost efficient route for yourself, is to actually raise that. I think the legal ombudsman route is a bit more consumer focused as opposed to cost law focused. Okay. So what they'll look at is what was the information provided to the client. For example, estimates, massively important now, not just for yourself, for legal ombudsman challenges, things like that, but also for managing client expectations. Because ultimately, if you're able to tell someone that they're going to be paid, like our fees are going to be £20,000, and you either come in at 20 or you come in a little bit below, 9 times out of 10, they're not going to be unhappy. And therefore, they're not even going to be thinking about these sorts of challenges. But if you put in maybe an artificially low estimate, or it ends up just getting out of control, and like with all litigation, it never goes exactly the way that you think it will go. There'll always be the odd diversion or a little bit of extra work that's just pops out, and you have to deal with it. It's those sorts of things, and then it's managing the client's expectations to avoid a nasty surprise, because that's probably the main reason why you get clients looking to challenge bills, is because something they've been given a bill which is far bigger than they thought it was going to be, and then they're like, hang on a minute, I don't think I've received the service for the bill that I've now got to pay, or has to be taken out of the estate, for example, and then suddenly they're not getting as much as a residuary beneficiary.
So what would your top tips be for those of us, all of us doing legal work, to what's the best practice? How do we avoid assessments if possible? But if they are going to go down there, what's the best defense in depth we can have?
So definitely client expectations, client relationship management is the number one. If you can keep the client happy, then you're going to avoid that at the end of it. So that's whether that's giving a real and realistic estimate at the start. Don't try and undersell yourself. Set out what you think the estimate is, so a figure, but also set out what work is included in that, and also what work isn't included. Because again, that will come back to that sort of that presumption of, well, actually, I said that I would do X, Y, and Z. I've done X, Y, and Z. I'm within estimate. Therefore, you'd agreed to enter into that retainer with me. Therefore, the court's unlikely to really assess it down, because the client's provided their informed consent for those costs to be incurred. So they can't really go renege on the agreement that they've struck. Likewise, always keep the client in the loop. So if things do pop up, explain and say, well, actually, this has come up. Give a revised estimate saying, actually, because this has come up, it's going to take us an extra whatever amount of time, or it's probably going to be another £5,000. If you can get their informed consent on that, again, you've got that sort of rebuttable presumption in your favour if it does go that way. And likewise, if the client's asking you to do something and you're like, this isn't going to be successful and it's only going to incur more costs. Tell them that, put it in writing in a letter, because again, you can then rely on that at an assessment and say, well, look, I told you it was going to cost you an extra £10,000.
Yeah.
It's actually only cost you £8,000, but this is all from following your instructions. I'd advised a different, more cost-efficient route, but you were intent to pursue some other aspect of a claim, for example. And again, it's showing that informed consent. And I think probably the most pertinent one at the minute is probably thinking beyond the initial client. So certainly for probate matters, the client is the executor 9 times out of 10, but beneficiaries are classed as third parties because your costs are going to be paid out of the estate. And following the decision in Hennig, third parties have more of a right now to have those costs assessed as well. So I think I would recommend any probate solicitor not just writing to the executor with estimates and costs updates, but also to the beneficiaries as well, just to keep them on side. Because again, the beneficiary is probably a sort of one step removed in respect of costs. At the end of the day, they're probably just wanting their inheritance, which is understandable. But at the same time, it's always a nasty shock for them if at the end you're like, well, actually, yeah, the estate was however much, £300,000, you're residuary beneficiaries, but actually because costs were this, you're only going to get a smaller sum than what they were expecting. They're always going to be a bit like, I don't agree with your costs. And if that comes out of the blue because they've not been kept in the loop, then the court's probably going to err on the side of that sort of consumer protection. And certainly since Kennig, that's opened the door, and we're very much in a sort of wait and see phase as the initial sort of challenges follow Kennig to see exactly what extent beneficiaries have to challenge those costs. So yeah, I'd recommend also keeping beneficiaries in the loop as well.
Okay. All hugely helpful, fascinating hints and tips there. And obviously, know where to find you if you need proper professional help on this.
Absolutely.
Kris, thank you so much. And I am sorry, I'm very distractedly. I'm admiring the background to your to you with all your F1 stuff. So if you're listening to this, you won't see it. But if you watch this, Kris got some great stuff there. So thank you very much, Kris. It's been an absolute pleasure, and thank you very much.